family mediation is a very, very good way of helping couples who are about to embark on a major, major life change, whether to separate or not, and whether to divorce or not. And sometimes couples, ex-couples, people come and see me if they wish to bring a family dispute to myself as a family mediator. So this could be a couple who have divorced already, they've been divorced a number of years, and they hit a dispute with their child or children, perhaps the arrangements are falling down, so they want to come to family mediation to try and resolve that dispute as amicably as possible. So round about this time, when couples are thinking, you know, of how to get help with a dispute, a separation or a divorce, there is a lot of emotions going around at the time. There's very often conflict, there's very often poor communication, there's often distrust and anxieties. And all of this sort of exacerbates the problems and the tensions. So often they come to family mediation from a rather sort of bad place. The emotional background to family mediation and resolving disputes is extremely complex and has to be understood. If a couple is contemplating divorce, very often one person in the couple is very, very for the divorce. And often the other party can be quite reluctant, perhaps doesn't want to divorce at all. So people are really at very different points, you know, when the mediation starts. And it's very important to understand, you know, what is going on and to listen to each party. Often the situation is even more complicated when there are children involved, because not only is there a real urgency in needing to make arrangements for the children, you know, for a divorcing or separating couple, and these arrangements must address their physical, emotional, educational and financial needs and well-being. But the hard bit is how to bring them into the mediation. And in the past, I think family mediators have neglected this. But in the last couple of years, I'm very pleased to say there's been a big sort of push in the family mediation movement that wherever possible, it should be normal for the mediator to see the child or children, you know, providing they are sort of over the age of 10 or 11, so that their independent voice can be heard in the family mediation process. Now, this really is quite a very interesting new development. Obviously, the consent of both parents must be sought, and the consent of the child or children. Obviously, there has to be a very confidential and safe space for the child or children to talk to the mediator. And because of COVID now, all of this is sort of done, you know, through Zoom or Skype or WhatsApp. And the parents have to be really, really, if you like, educated so that the children are not primed in any way. You know, tell the mediator you want to live more with mummy, or tell the mediator you want to live more with daddy, or whatever. So the parents have to be talked through this process, that they must not prime the child or children, and also the child is guaranteed absolute confidentiality in the confidential session with myself, and only what the child or children give their agreement as to what can be fed back to mum or dad is then fed back to mum or dad or both. So there is quite a sort of strict process that has to be followed. But where I have done mediation with children, and I've explored what the children are thinking and feeling. It has been incredibly helpful and incredibly useful. And this is not in any way to take away the decision-making powers from the parents, because only the parents absolutely can decide, you know, what happens to the children. But it's to give the children a voice in the process, you know, which up until a few years ago did not really happen. So this has been a really big change. And we are all family mediators are now normalizing this aspect. Okay, so just to go back a little bit more to an overview of family mediation itself. Family mediation is a form of alternative dispute resolution. If you like, it's the very first rung on a ladder for separating parents. More and more solicitors are now recommending family mediation because it's a voluntary and informal, confidential and helpful process. By a long way, it is so much less stressful, cheaper and quicker than going through, you know, litigation and an adversarial court process. So it's a very, very good form of ADR. People come to mediation, family mediation, particularly when separating, in order to hopefully mutually and amicably talk through and resolve their asset sharing, you know, their property splitting, perhaps pension splitting, child arrangements, communication, and future living arrangements. You know, for instance, the family home. Is there a chance one party might continue living in the family home, buy out the other party, or should it be sold? And then both parties have to look for new accommodation. So all of these decisions take place in family mediation. And I think the beauty of family mediation is it's voluntary, it is confidential, but having said that, obviously if I hear, you know, there's been any criminal activity or there's been any safeguarding issue, you know, child abuse, then that has to be reported to the appropriate authorities. And I make that very clear at the beginning. It's a very empowering process, and I'm sure many of you listening who are civil commercial mediators will recognize how empowering mediation can be. For clients to reach their own decisions and actually be able to discuss from their initial statement of their positions to discussing their needs, to discussing, you know, their wishes, it's a very, very great process. At the end of family mediation, if my clients reach agreement, and something like 70% of my clients do reach agreement, those agreements are then written up, and those documents are called a memorandum of understanding and an open financial statement, you know, if it's finances as well. And those two documents are then taken to the party solicitors for legal checking and then to be made legal. Okay. Now, some people choose not to go through family mediation, and they have the options of going, you know, to a solicitor, perhaps a collaborative lawyer, and you can have solicitor to solicitor negotiation. And you can also obviously go to the court, and then a judge will make the, you know, the actual decisions about the division of your financial assets and child arrangements. But obviously family mediation is what I recommend, providing it is suitable and providing there are no reasons to prevent family mediation taking place. So let me just say a little bit about the first stage in this process. Yeah. it has been the law for the last few years that before anybody goes to court, they have to have an initial meeting with a mediator, unless there are exemptions, you know, such as domestic abuse, violence, you know, a non-molestation order, etc. So this meeting with the mediator, this initial meeting is called a MIAM, a Mediation Information and Assessment Meeting. And I must say this is really has been a very useful way of getting people to hear about mediation and consider the benefits of mediation and so on. And I use the format of the MIAM, the Mediation Information and Assessment Meeting, for all my clients now, simply because it's such a useful tool. So let me just tell you in a nutshell what I do in this initial consultation meeting, or MIAM. Yeah. First of all, I do a thorough welfare screening, and I check whether there has been any, for instance, coercive control, you know, bad behavior, bullying, intimidation in the relationship. And obviously the MIAM, the consultation meeting, has to be with each party separately, first of all, and in confidence. Yeah. I mean, some mediators, but they're getting fewer and fewer now, see the couple together for the MIAM. And I must say, I have tried it once, but it is much better to do it separately, because only then does each party have the freedom to really go into, you know, the state of the relationship and so on. So you can assess whether mediation is suitable. And if it's not suitable, then you do not mediate with the client. The other part of the MIAM is obviously to take a little bit of the history, you know, the story, you know, what's going on, what has brought them to wanting mediation, what are the factors that need consideration, and an explanation of the process of mediation during this consultation meeting and the other forms of ADR that are there as well, you know, such as collaborative law. So the MIAM, in my mind, is really, really key. Okay, so that's a little bit of an overview. In terms of some of what I do in family mediation, let me just go back to children again. Sometimes it's really, really useful to produce a parenting plan if there are children involved, because the parenting plan, and I use the Kafka's template, which is available online, gives a very good scaffolding structure which can be looked at in a very voluntary way with the separating couple. And it discusses things like, okay, what happens in term time? Where will the child be living? What happens in holiday times? What happens at Christmas? You know, how will you divide the half terms, if at all? How will handovers be enacted? Can there be good cooperation between the parents generally, so that the health and the well-being of the children, you know, can be positively promoted? And I must say, I do find as a family mediator that it is not the separation or divorce process itself which potentially can harm children. It is the level of communication between the parents and whether the nature of that communication can be hostile or can be collaborative and cooperative. And obviously, as a family mediator, I do everything possible to encourage a cooperative and a helpful you know, dialogue, engagement, co-parenting between the parents. And it's very, very sad sometimes when I see that children have become weaponized, you know, and so the starting point is sometimes perhaps mum is refusing access to dad because child maintenance payments haven't been paid, or the child maintenance is not enough, or one party has another partner, so the other partner refuses to let the child or children, you know, see the other party. And it's really, really sad. So I do everything possible to try and, you know, help the parents to move forward, so that somehow that level of hostility can be lessened and a cooperative arrangement can be brought about. And very often I make transitional arrangements with the parties. So perhaps they might agree something for 3 months, you know, something for 6 months, and come back, and then something for, you know, for the future. Because it's such a delicate area, and these matters should not be rushed. So I've referred already to the voice of the child being heard and how important that is. Now, with regard to what is very, very much a normal form of dispute in family mediation, is the parents often come, or the parties can often come, and they are worried about their financial matters. And what I do is I use, as a financial disclosure, I use Form E, which is the same financial disclosure form a solicitor uses. And each party commits to making full, honest, transparent financial disclosure. And this is terribly important, so that before we can move to any, you know, discussion of sharing of assets, this full financial disclosure must be made. And obviously I help parents, you know, with this. Right, so moving on. Those of you who have a legal background might be familiar with this. It's very, very important that clients understand that family mediation is not a soft option, in the sense that we have to pay absolute attention to the law. And there is a law called Section 25 of the Matrimonial Causes Act 1973, which discusses and details how fairness in financial matters, you know, on divorce, should be reached. And I use this all the time, and it's a most useful tool, because you have to address the needs of each party. You know, if it's divorce financial mediation, the needs of each party are critically important, which obviously goes into the health of the parties, the age of the parties, their earning capabilities, you know, their financial needs, their responsibilities, the standard of living that they enjoyed when they were together, their age, conduct, contribution, and so on. So the needs of each party is really, really important. And I give out something called a monthly expenditure sheet, so that the parties can work out, you know, how much they need per month to survive. You know, and that drills down to their food, their utilities, their personal expenses, and so on. And I also ask them to try and work out, after divorce, what their future monthly expenditures might be. Because often, you know, if each party perhaps is going to move into different accommodation, there'll be mortgages to pay, rents to pay, etc. So the financial needs and the personal profiling, if you like, of each party in terms of, you know, their specific needs, really, really important. So apart from looking at the needs of each party, you have, you know, the sharing principle, that on the whole, assets for a medium long-term marriage, anything over 10 or 11 years-ish, should be divided equally. And this applies to pensions, this applies to assets. So it's really important to explain to clients that, you know, any mediated agreements have to be within, you know, what a court would approve. So Section 25 of the Matrimonial Causes Act 1973 is really important. And the other bit of legislation, which I also share with my clients, if there are children, is that there is something called a welfare checklist from the Children Act 1989, which states that the wishes and the feelings of the child, critically important, the child's age, sex, background, whether there's any harm to the child, the capability of the parents, and the child's physical, emotional, educational needs, and so on, all come into the discussion. And I find, you know, with the parenting plan, we do go through all the minutiae so that the needs of the child can be uppermost. And obviously at the end of the day, the children come first in divorce consideration and divorce matters. Now, many of you out there, civil commercial mediators, you know, other types of mediators, general public, will not be amazed at all at what I'm going to say. Family mediators are part of a whole network of professionals. And when it is suitable and important to do so, we recommend at critical points for our clients to seek independent pensions advice, independent legal advice, independent financial advice. If there is a lot of emotional upset, then I might very well say, let's sort of, you know, put a hold on the mediation for a month or so, and to get some counselling support if that's needed, or perhaps to see a divorce coach. Very helpful in supporting people through divorce and so on. So it's really important to signpost people to other resources, to other professionals, to read books and articles as appropriate, and to use resources. I mean, there's a wonderful handover book written by a colleague of mine, Ashley Palmer, which helps separated parents, you know, to sort of jot things down in a handover book, and for the child to jot things down, you know, so there can be really good communication about what has been happening, perhaps in the week when mum or dad hasn't seen the child. So very important to use other professionals and resources. Reading lists I give out as well. And, you know, and information in general. Right, so what have I learned from being a family mediator? Okay, and again, you mediators out there listening will find many of this, I'm sure, common sense. I find kindness to each other when you're mediating a dispute or a conflict between two people. Kindness to each other is really important. And I find sometimes, you know, you're moving from a place where there is so much conflict, lack of trust, hostility at the start of the mediation. And then maybe after a couple of sessions, one party makes a kind gesture to the other party, and that completely can change the atmosphere. So kindness is really important. Cooperation is really important. And where parties can have an open mind, you know, in their problem solving in their work in mediation, this will reap benefits. I've also learned how important respect is. Okay, respect is not just a word. It's a real sort of attitude, a real attitude of mind. And I always emphasize at the beginning of the family mediation, you know, that they have signed up to the agreement to mediate, which absolutely stresses the importance of working respectfully with each other and the mediator to look for solutions. So respect is really important. I've also learned, and this is a little bit, you know, going back to the years when I was a counsellor before I became a family mediator, the importance of actually listening to what is being said. And I think when clients feel that the mediator is actually listening, you know, to what they are saying, and they're actually being heard, then the mediation can move very, very quickly. So it's important really not to be thrown by the negative emotions, which will always be present at the beginnings of a dispute, because by its very nature, if you're in dispute and in conflict, there will be negative emotions. So it's very, very important to use all your mediation skills, you know, to try and diffuse that anger or hurt or fear, so that you can proceed with the problem-solving element of the mediation. And the tools in my kit bag, are, I'm sure, very, very normal tools which mediators use. They are conflict management skills, counselling skills, obviously theoretical knowledge, knowledge of the law, the ability to signpost to other professionals and to resources, and obviously to have confidence in the process itself. So you really need to know the process, explain the process at the outset to your clients, know the boundaries, have good supervision yourself, and obviously keep up to date with training, you know, in your field. And I think the other thing that I'm really must share is the benefit that I have personally got from fellow mediators, from mediators I have worked with in the past, you know, when I did community mediation, when I did workplace mediation, you know, many years ago before I was a family mediator, from the mediators I co-mediate with sometimes, from my, you know, trainees whom I've taken on, as I'm a mediator supervisor as well. And it's terribly important always to learn from colleagues. And just one last thing, but before I finish, a colleague just pointed out, reminded me of this sort of yesterday. A lot of people don't know that family mediation can be accessed through the legal aid scheme. Yeah, so obviously if you come across people on low income or on benefits, they can have free mediation through a mediator who operates under the legal aid scheme. So that's really important to know. Okay, so that's the end of my talk, and now I'm happy to answer questions.